Sovereign citizens challenge the law, but the courtroom has no mercy. Watch as their defiance leads to shocking consequences. Who will survive?
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
On the second.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here,
Okay.
what your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the, we'll file it.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
Yeah.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm going
to little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be around and be available for you. Okay.
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay, thank you.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. It's just the city of Detroit versus Albert Himmer Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
Hey, everyone, welcome back. Today, we've got something unique lined up for you. We're diving into the courtrooms where sovereign citizens come face to face with the law. It's a wild ride with some familiar faces and shocking new cases. Trust me, you won't want to miss this one.
You're your own attorney. You're an attorney registered by the state of Michigan.
Licensed to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date or you want the offer in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right, well,
I'm
trial
challenging
date,
jurisdiction.
trial date, I'm denying, what is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so,
Honor your oath of office, please. Honor your oath of office, okay?
are we going to sit here and debate those
It's not
positions?
a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know
so,
so. Are you violating my constitutional rights on how you deem them to be?
no, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have
Please.
a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you gonna do today, Mr. Hicks?
Challenge jurisdiction
And how are you challenging that?
because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case,
Okay.
and I deny that motion.
Why you
If
denying
that-
the motion? Because you don't have.
Even
have.
if that is, that's so Mr. Hicks, you're a grown man.
Citation needed.
Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." That's what the court rules are. You got to follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything here. That's all public information.
You're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a
I
license
thought about that. Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to
again. All right. Now I'm going to give you one more time to interrupt me. if you interrupt me again, I'm gonna hold you in contempt of court, okay? All right, so the other option is we set a jury trial. And we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm gonna allow you to exercise that jury trial right. I'm not gonna sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
No, you don't.
You didn't answer my question, so I'm moving on, and I'm gonna put you out, or at least mute yourself. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we gonna do? The officers were supposed to be here today. I'm only dealing with SP 144, 2547, counts 1, 2, and 3, SP 144, 27651, and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're gonna make this easy. And now, what I don't appreciate is, you know, I thought about that comment that you made that last time. You know, it basically you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm gonna dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
Children, pay close attention to the look on his face as she testifies against him at his probable cause hearing.
Is that Mr. Albert Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay, how long were you guys partners for?
Around 14 years.
All right, let's kick things off in Kansas, where we have an update on a familiar sovereign citizen I covered almost a year ago. This guy thought he could slip through the cracks and avoid any real consequences. But, spoiler alert, things didn't exactly go his way.
So, for the record, I've made this special dissertation under duress pertaining to the matters of Jonathan Troy, Faifole Somaliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality? And what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
that would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenge the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be.
Here's the part where he truly believes he can go solo without a lawyer. It's like watching someone try to build a house without tools. He insists he doesn't need an attorney, but the judge is setting him up for what's to come. You can already feel the tension building as this sovereign citizen stumbles through his own defense. Will he get away with it? Let's see.
It would just add to that. And I don't think that you need to go that route.
While I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but.
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
Moving on to our next case, we're looking at one of the most arrogant sovereign citizens I've ever come across, Albert Hicks. This guy doesn't just challenge the system. He thinks he can outsmart it at every turn. But trust me, no amount of legal jargon is going to get him out of this mess. The judge isn't having any of it, and the drama is about to unfold.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating.
Again, I was not driving. Again, I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
Now, Albert Hicks is really pushing it. The judge is trying to keep it calm, but Hicks just can't help himself. He continues to make it personal, challenging every single ruling and authority. It's clear that Hicks thinks he's above the law, but let's be honest, he's about to face the music. Keep watching because this is where the real heat starts.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle municipal case and see when he's next scheduled to
like
appear.
you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Malietoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
it's not a threat. It's just what it is. Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
when are you setting that court date, Miss?
Required by the Department of Licensing. You are, you will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges that have significant consequences for you. So it's in your best interest to have counsel.
Again, I stand on my own 2 feet. I do not need to be represented by anybody. I present myself sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right, the time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be on June 24th. That's 2 weeks out.
So for the record, you have not established status, you have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench. You're asking me to sign something that you pleaded for me. Is that correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said yes, you pleaded for me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice, and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I
piece
do
of
not
paper
understand how
with
you can
the
practice
document?
law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty. So on your behalf, I'm entering a not guilty plea.
So correct, you
cannot-
are pleading for me,
There's
correct?
2 pleas.
And if you
Not
plead
guilty
for me,
or
you're
guilty.
practicing law from the bench. You cannot practice law from the bench, so I object.
Right.
You're-
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay? All right.
Jennifer Grant, you will be
Okay.
taken further.
At this point, the judge has had enough. Albert Hicks is digging himself into a deeper hole with every word, and the judge is losing patience. The decision is clear. He's running out of options. The more he protests, the tighter the noose gets. You can feel the tension in the courtroom building up, and it's only a matter of time before Hicks is forced to face the consequences of his actions.
All right, now we're going to move to Habib versus Bouvier. All right, so remember when we last came on this matter, there were some issues that had come up that the court was not quite aware of. I think it may have been the reports. I had not yet read them. And some of the things that were being said, I wasn't familiar with. So I asked everybody to come back so that I can read through those reports and have a better understanding of the backgrounds of everybody. And so I've had a chance to.
Your Honor?
Oh. Okay. So the court had an opportunity to review those and has a better understanding of background. I can't remember exactly how far we got in there. I don't know if Ms. Giles even made recommendations at that time. I don't think we got that far, but I'm not sure if you all remember or not. But I have read the recommendations in the report.
I don't think we got that far last time, Your Honor.
Okay, all right. So the let's see. So since I have that background, let me start by calling Ms. Giles. Raise your right hand. Please tell me swear or affirm testimony about to give in the case is the truth, the whole truth, and nothing but the truth to help you God.
I do.
All right, and if you would, we have Ms. Bouvier. Ms. Bouvier, you need to turn your video on because we're in the middle of middle of the hearing now. So you have to have your video on. You turn your mic off, but your video needs to be on.
Your Honor, for the record, before we proceed this matter, there are some facts I must state for the record. I'm here on special restricted appearance as the representative of the descendant. And I do not wish to waive any rights, rather statutorial or procedural. And for the record, as the authorized representative, executor, beneficiary, I have demanded a jury trial in regards to this matter. Moving forward, for the record, Your Honor, I have filed an amended notice of recusal with an affidavit of fact on May 29, 2024. With all due respect, Your Honor, I have not received a response from you in regards to this notice. Please note for the record, I have presented to this court on special restricted delivery all presentments to date. Moving forward, according to Georgia Code Section 1512-122 and 2020 Georgia Code Section 91138, rights to a jury trial is a reserved right.
Now on to Ms. Burr, who's apparently playing by her own set of rules in this custody hearing. The judge gives her a final warning, but Ms. Bouvier just can't keep her cool. She thinks she can manipulate the system with her sovereign citizen beliefs, but the judge is stepping in hard now, showing her that no one, no matter how big their ego, gets to override the court's authority.
Please note for the record, at this time, I do not wish to add nor subtract anything from my presentments, and I stand behind my documents. And at this time, I respectfully excuse myself from this proceeding to await all notices concerning the trial by jury according to the law.
Okay. So first, you filed a motion for recusal, which the court denied. Looks like you filed, you need to turn your video back on. If you don't turn your video back on, I'm going to have a hearing without you. Okay, so turn your video back on. All right. You filed a motion for recusal, which the court reviewed and denied without there being sufficient evidence. I think you filed an amended one, which the court did not receive a copy of. You were supposed to send that to Chambers if you actually wanted me to respond to it. But you filed it via e-file. I'm noticing it now. It's going to be denied for the very same reasons. With regard to your request for for a trial, this is a custody matter. It cannot be a trial by jury because you can't have a trial by jury on a custody matter. So that issue will be denied. As for your representation, the court will consider you London Bouvier. That's who you are. That's what the court consider you as. If you want to consider yourself as anything else, that'll be up to you. But when I make a decision, it's going to be for your government name, London Bouvier. And that's what the law of Georgia is going to hold accountable. So when you don't do what I asked to do, your representative or whoever you think you might be won't be going to jail. It'll be you, London Bouvier. Okay. So I want to make sure you understand that. So is that clear to you? All right. We're going to proceed in these proceedings. If you want to participate, that's up to you. If you don't want to participate, that's up to you. But I am going to make a ruling and the law will be what the law is. I suggest you should participate so that you can be heard and that the concerns that you have, the court will have an opportunity to hear them. That'll be up to you. Has this order been followed? Is it being
Your Honor, that's why we're here.
It's not being followed.
No.
No, right. We filed a contempt on this order on May 7th.
Really? I had thought that this matter was coming back on the calendar because I continued it from the last matter, but now I understand. Okay, so there is also the contempt on the interim order.
That's
all right.
correct, Your Honor.
Got it. I got it. All right. Yeah, all other issues shall remain. Okay. All right. So the order isn't being followed.
That's
It is
correct.
not. That's the issue. It being followed at all, like no visitation or just being,
No visitation at all, Judge.
all right, Ms. Bouvier, I've indicated to you once before that your video has to stay on. This will be my last warning to you. Turn your video on. Ms. Bouvier, if I say it again, I'm going to find you in contempt of court. If I say it again, I'm going to find you in contempt. So when any issue happens before, I'm going to have my deputies come get you. Okay? You turn it off again, I will find you in contempt of court. All right? So you will spend 10 days in the DeKalb County Jail. You turn the video off again. Okay? Did you understand me, Ms. Bouvier? Did you understand me, Ms. Bouvier? Unmute yourself and say so. Ms. Bouvier, I'm going to ask you one more time. I'm going to excuse you from this hearing. I'm going to find you in contempt, and I will pick you up. And your child will then go to Mr. Habib. Unmute.
I stand behind my documents. For the record, I stand behind my documents.
You can stand behind whatever you want. Do not unmute like I asked you. Ms. Marshall, go ahead and remove Ms. Bouvier from these proceedings.
Yes, ma'am.
I find you in contempt of court. 10 days in the DeKalb County Jail. Child will be presented to Mr. Habib.
And that's a wrap for today. We've seen some serious defiance in the courtroom, but as always, justice has a way of prevailing. If you enjoyed these cases and want to see more shocking courtroom moments, don't forget to hit that like button and subscribe. Let me know your thoughts in the comments, and I'll keep you updated on any new developments. Stay tuned, because the courtroom drama is just getting started.